The Supreme Court is starting to make me a little nervous, guys.
Case out of Montgomery County is now in the hands of the U.S. Supreme Court. Parents say their religious rights were violated by the local school board, and now the nation's highest court will decide what happens next.
What we struggle for today, it is for future generations.
Our children, our decision.
Tensions high outside the Supreme Court as justices take up a case that could reshape parental rights across the country.
Instead of respecting our role as parents to guide our children's education, the board is imposing lessons on gender transitions.
A group of Christian, Muslim, and Jewish parents sued the Montgomery County Board of Education in 2023 after being denied the choice to opt out their children from a list of LGBT books starting in elementary schools.
Yeah, but you see, not all these books are this innocent. They start with this, but this is just a stepping stone to some of the other books that they've got in these libraries in school.
Hi, my name's Knox Zajac. I'm 11 years old and I go to Wyndham Middle School. I'm a 6th grader. I was in the library and this book was on a stand. I'd like to read you a page. My back over my hips as I ask if we should take our clothes off. And he's saying yes before I finish my sentence. He's pulling off my t-shirt, laughing when I can't undo his shirt buttons. He's undoing my belt. I'm reaching into his bedside drawer for a condom. It was kind of terrible because we didn't know what we were doing. Now, this book was at my middle school and it was on a stand. When I rented it out to show my dad it, the librarian asked if I wanted more and if I wanted a graphic novel version.
This material is just like in schools now. And if we want it off the white list of reading materials approved for being in school, apparently we're trying to ban books. Are these people insane?
This includes books for kindergartners such as What Are Your Words, which tells the story of a child who claims, quote, "My pronouns are like the weather. They change depending on how I feel." The books are offered as a part of Montgomery County's language arts curriculum.
Kindergarten? Are you serious? See, that's the first red flag. They start sticking the word arts on the end of these curriculums. It's code word for indoctrination program, like 99% of the time, it turns out. What they're trying to do is mess these kids up even further by deconstructing the concept of identity so they can riddle them with insecurities that can be manipulated through the marketing industry and they can build perfect consumers. So there's a lot on the line here when these parents are going to the Supreme Court and saying, hey, we need you to step in and support us in actually parenting our kids here and not having them indoctrinated by the school program. And y'all, what I'm hearing coming from Ketanji Brown Jackson right now, while she's hearing arguments coming from the lawyers for the parents, she sounds like opposing counsel. She does not sound like an impartial judge.
But I need you to focus on my question. This is a preliminary injunction. I appreciate that. When you seek a preliminary injunction, you actually have to have a factual record that is the basis for the court to make a determination in your favor that some conduct that you're complaining about needs to be enjoined. And what's confusing to me and hard, really hard in this situation is that we have a lot of sincerely held beliefs and concerns and children and principles, and I see all of those things, and so really want to be careful about making the pronouncement that relates to this.
You want to be careful about allowing parents to opt out of a sexual curriculum in school? Just to be safe, we'd better lean towards the side of forcing people to comply? I don't even think she believes the crap coming out of her mouth right now, to be honest with you.
I don't understand how we can do it on this record because we can't know. We don't at this moment, based on the record you've provided, know that these books aren't just sitting on the shelves.
Did you guys hear that?
We don't at this moment, based on the record you've provided, know that these books aren't just sitting on the shelves.
This entire case is in front of the Supreme Court because these parents want the ability to opt out of a curriculum in which these books are being taught directly to their children by the teachers. And that ability has been removed by the school for them to do that because 90% of these parents were opting out.
I disagree, Your Honor. The record is undisputed. And I, again, will refer you to the district court transcript at 63. Where counsel
so you're saying the Fourth Circuit is wrong when it says, quote, we don't have any information about how any teacher or school employee has actually used any of the books.
And now she's arguing with the parents' lawyer. She's so pissed off at what he's saying, she has to interrupt him to now interject her own points. What is she? She's opposing counsel at this point, dude. She's the judge. She's the one opposing counsel would be trying to convince. She doesn't have to be saying anything except for in her own head and to the other justices. What is going on right now?
The Court of Appeals did not dispute that some of the books have to be used, and we have all of the teachers' instructions that the board's not disputed.
I understand that, but the Fourth Circuit made a ruling that we don't know, quote, what any child has been taught in conjunction with their use.
So she agrees on the meat of the case that these books that are inappropriate, have concepts inappropriate to be taught to children, especially at those ages, are being used in the curriculum, and these parents want the ability to opt out. And now she's arguing the parents should not have the ability to opt out because in the technicality of the Fourth Circuit's ruling, they don't know exactly how these books may or may not have been used, except it's clear enough, regardless of exactly how per se. It should have been an opt-in program to begin with, especially if that many people don't want to be a part of it. See, the crazy thing is they originally had the ability to opt out, but that ability was removed because it was like 90+% of the parents were opting out. And I guess they want to force these children to be indoctrinated. But at least Ketanji Brown Jackson's got some balls. The justices with their heads on straight, it seems like they got no heart.
The board came out and said, we're changing the rule because we want all students to be instructed on inclusivity. That's at 547 in the appendix. That emphasis on all students have to receive this instruction. Nothing about administrability. And then from there on, even then they said, if we've already told you you can opt out, we'll let you do that, but more parents can't ask. And then it wasn't until later in the year when they actually revised their guidelines, which still allow certain religious opt-outs and just not others. So this was clearly targeted at religious parents objecting.
But then complaints were raised, right?
That's right. Hundreds of parents complained. These were mostly, according to the news articles, mostly families from Muslim faith and Ethiopian Orthodox who were objecting when they spoke to the board. The board accused them of using their religious beliefs as another reason to hate, accused a young Muslim girl of parroting her parents' dogma, and then accused the parents of aligning with racist xenophobes and white supremacists.
You want to talk about being in a cult, man. Everyone who disagrees with me is a xenophobe and a white supremacist. It doesn't matter what they look like, who they are, where they come from, or why they're disagreeing with me.
And so, again, there's no question in this case that there is a burden, that it was imposed with animosity, and that it's discriminating against our clients because of their religious beliefs.
Thank you. Justice Barrett.
So, counsel, we've talked a lot about burden, and I'd like to get a definition. So Justice Sotomayor's questions, I think, track what the Fourth Circuit said, which is that compulsion is required. That's not your position, that compulsion is too far, right? So can you precisely define for me what it means to have a burden?
Yes, I think there's three main ways this court has reviewed that. Under Yoder, it would be, is there substantial interference with the parent's ability to direct the religious upbringing of their children? We think we've shown that here. Under cases like Sherbert that have continued through to Fulton, it's, are the parents being pressured to abandon or modify their religious beliefs in order to access a public benefit, like public education? And then I think we also have what I think Justice Gorsuch may have been suggesting, just if there's straight up discrimination where some religious students are opted out and others aren't, then that itself would also be a burden. And I think we satisfy any one of those tests.
Okay, I have questions for you about those tests, but I'm going to bracket them to just follow up on the burden.
Amy Coney Barrett, conservative justice. Sounds like she's not too thrilled about the idea of parental rights. I know I'm not a legal expert or whatever, but to me it seems pretty cut and dry that parents should have the ability to opt out of these disgusting sexual indoctrination programs. And if 90% of parents in your community are trying to opt out, maybe it should be an opt-in thing to begin with, or maybe you shouldn't be doing it at all, buddy. And while the Supreme Court is over here weak in the knees, we got the left screaming about a fascist Supreme Court nightmare, and they can't wait to pack the court next time they get into power. Like, bro, this is all we got? This is the nightmare? Anyway, I'm done ranting. You guys rock. I appreciate it, and I'm gonna see you on the next one.